Presentation of the Parliament Channel and Parliament Radio 105.5 FM.
The chair.
Honourable Senators, shall we resume the proceedings of the committee?
Clause 7.
Honourable Senators, the question is that Clause 7 stand part of the bill. There are two amendments circulated for Clause 7. One circulated on behalf of Senator Shriki Soon and one on behalf of Senator Mark. Senator Mark, again, because yours is shorter.
Yes, thank you, Madam Chair. Yeah, Madam Chair, as I indicated earlier to you and this body, we intend to revert to the Tax Appeal Board with more resources, human, financial, and other technical resources, in order to give effect to this piece of legislation as it relates to appeals by members of the public who are property owners and who have not been satisfied with their notices, re-valuations coming from the Commission of Valuations. It is in this regard that I have proposed the deletion of this amendment or this particular clause. We do not support the minister having any role whatsoever in this matter via the tribunal, and we believe that we should retain the Tax Appeals Board, and the president, as you know, Madam Chair, is the person who is responsible for appointing the chairman and the vice chairman of the Tax Appeal Board, and all of them, and of course, all of the members are appointed through the Judicial and Legal Services Commission. So they have tenure of office, and they are not subject to any one's dictate or dictates. So it's against that background, Madam Chair, that I'm suggesting or proposing that we delete this clause completely.
Minister?
I'm a bit confused because based on my documents, Clause 7 deals with Section 9 of the legislation, and there we have replaced President with Minister, but it relates to the issue of fresh valuations, nothing to do with the tribunal, Madam Chair.
Well, if you go to, Madam Chair, let's go to clause 9.
Seven.
No, section 9 of the Act is amended, okay? Madam President, if you go to section 9 of the original Act, subsection 2, when we use the term president, there we are referring to the President of the Republic. And it's against that background, I'm suggesting that the President has a very big role to play in the context of the Tax Appeal Board.
Okay.
My response, Madam Chair, is that this subsection has nothing to do with the Tax Appeal Board. It has to do with the issue of a fresh valuation every 5 years.
Well, Madam Chair, well, maybe I'm not too clear on this one, and maybe you as a lawyer, in your capacity, you can advise me whether we are talking about President, Madam is an attorney at law. The President here in section 9, subsection 2, I'm interpreting it as President of the Republic. If it is the Cabinet in this regard, then I'd like to be so advised. Are we referring to the Cabinet in this instance?
Senator Mark, I'm not disputing that we have replaced President with Minister. What I'm saying is that the power that is being conferred on the Minister is the power to determine when fresh valuation shall come into effect. Nothing to do with the Tax Appeal Board or any tribunal.
Okay.
Yes?
Okay. But we are talking about the same President, right?
We are talking about the President of the Republic. That is correct.
Well, I want the President to remain.
Okay, so in response to that, I will refer you to the section that we discussed earlier,
Right.
which relates to the new clause 7A2.
Clause 7.
That is, section 7A2 introduced by clause 6 of the bill.
7A.
7A2.
Right, okay.
Under that provision which we have approved, we are conferring on the Minister the right, once he gets the notice in writing from the Commissioner of Valuation, to declare the role in effect. What the section 9(2) does is to allow the Minister to declare the new role in effect. So it is a roll-on activity. And I would recommend that it would be best to be placed in the same functionary rather than to have different functionaries.
So are you saying, Honourable Minister, that you're just trying to address a situation that ought to have been corrected earlier in terms of this legislation? Because the parent act that we have before us, in order for us to compare the current matter that we are dealing with, we have in section 9, subsection 2, the President.
We do.
And you are saying that you want to clean up this by removing the President and replacing that with the Minister.
We want to maintain consistency.
Okay.
So, Honourable Senators, the question is that clause 7 be amended as circulated by Senator Mark. Those in favour say aye.
Aye.
Those against say no. No. The noes have it. Therefore, clause 7 as circulated by, the amendment as circulated by Senator Mark is not accepted. Senator Shriki Soon, you also have an amendment. Can you just indicate the purpose of the amendment, please?
Sure. Thank you, Madam Chair. Through you. If we go to clause 9 of the bill.
No, clause 7 of the bill, clause
7
9 of the
bill.
Act.
Yes, correct. Thank you, Madam Chair. It reads, a fresh valuation in respect of land shall commence as near as may be to 5 years from the date of the last valuation of the land, as recorded in the valuation roll. And just for the purposes of being a little bit definitive, I didn't see what really constitutes the valuation roll. And hence, I looked at the definitions and realized it wasn't there. And given that reference is being made to one, I thought that, I don't know if it's an oversight on my part, but I thought it would be necessary.
Minister.
Senator Shriki, so if I, through the chair, if I can refer you to section 16 of the Act, which says that a valuation rule shall be prepared, and it lists the information that is included in the rule. So I think that adequately covers the issue that you're raising.
Thank you, Madam Chair, but if I ask the question, what is a valuation rule?
And I would say to you, the valuation rule is the document prepared by the Commissioner in accordance with Section 16.
Okay. Sure.
Mm-hmm.
Thank you.
Yeah. Senator Shriki-Soon, are you? Yeah, so Senator Shriki-Soon has withdrawn his proposed amendment. So the question is that Clause 7 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 7 now stands part of the bill.
Clause 8.
Honourable Senators, the question is that Clause 8 stand part of the bill. Senator Shriki-Soon, you have circulated an amendment. No, Senator Marks, so my apologies. You have circulated an amendment to Clause 8.
Yeah, Madam Chair. We live in the real world, as we are all conscious of, and the postal services in this country is not at, it does not operate at the level of efficiency that we would all want it to operate. And therefore, there's a certain level of unreliability. And Madam Chair, you will realize that under Section 8 of this legislation that we are looking at, innocent people can be prosecuted if things arrive, mails arrive late. The action can be taken against them. And therefore, it is incumbent upon us to ensure that we do everything in our power to facilitate the property owners to have access to the correspondences or communications that are issued by the Commissioner of Valuations. And therefore, I would like to suggest, in the case of Jamaica, Madam President, Madam Chair, they have something called prepaid registered letters. Now, I don't know if in Trinidad and Tobago, through the Chair, Honourable Minister, do we have at the postal level prepaid registered letters or posts?
I'm unable to respond to that, Senator Mark.
So that is why I've included, Madam Chair, registered posts, so that, for instance, we will hold the postal services accountable to getting the correspondence to the owners or to whoever the correspondence is being sent to, rather than then send it, Madam Chair, ordinarily by post. It may never arrive. In fact, I think it was Senator Small who brought to our attention recently. It took him 11 days or 15 days to get a simple piece of correspondence from
So that, Senator Mark, I think that to just summarize what you're proposing, that yes, it be by registered post.
Yes, that's what I'm proposing.
Senator Mahabir.
Thank you very much, Madam Chair, and through you, Madam Chair, to the Honourable Minister. And it's an elaboration of Senator Marks's point. I note in Schedule 2, Honourable Minister, under personal information in Schedule 2, we ask for the owner's name, contact details, email. There has to be a reason to ask for the citizen's email address in addition to his telephone number. And I was just wondering whether, in order to expedite the process of making all government agencies much more computer compatible, you're not going to add in Clause 8, in Section 13 of the Act as amended, you put notices by being sent by post or email, since we are asking for the email in Schedule 2. And I think if we are to do that, we could circumvent some of the problems alluded to by Senator Mark. And we are sending notices now via email. It's a record. It is a record sent by the relevant agency, the Commissioner of Valuations. And the thing with email is this: once it is sent, it is sent. If it is not delivered, it bounce back. It will bounce back. So that I think the government as a general policy, in addition to you as Minister of Finance in this particular bill, should consider, once we ask citizens for their email, to use it in addition to the snail pace, which can be unreliable.
Any other? No? Minister?
Senator Mahabir, the intention has, and the reason for requesting email is so that we can efficiently communicate with owners via email. We didn't think it was prudent to put it in the legislation. I could confer with the drafters and get their view on that. The reason why we have moved away from registered mail, and you would see when you look through the legislation in general, you would see what we have done is suggest ordinary mail or personal delivery where there is no obligation on the owner to act. Where he has to object within a particular time or pay within a particular time, registered mail is required. But for notification, and you will bear in mind that the role is a public role, so the owner has access to it, will have this information, and the delivery of the information by mail is a formality. So we thought in those circumstances we didn't need registered mail for this particular purpose, but we have it elsewhere.
Madam Chair, if I may ask through you to the Minister, why then are we proposing in Clause 8, subsection 4, why are we proposing or suggesting a timeline not later than the 15th day succeeding the day when posted? And that's a person who is residing in TNT. And then for a person who is not resident, not later than the 30th day. So in other words, Mr. Chair, Madam Chair rather, there is a timeline. So even though ordinarily, as you have said, there is no compulsion, why are we setting a time frame? So therefore, remove the time frame. There's no need to set a time frame. Yeah. You put a time frame because if they don't respond around that time or immediately after that time, then the onus is on them. And that is why I'm saying that it should go registered and not ordinary.
Mahabir, you wanted to add something?
I just wanted to go a stage beyond that, and looking at the idiosyncrasies, peculiarities of the Trinidad and Tobago Postal Service, you never, ever get anything online. Those of us who have to pay credit cards via a particular date will never get a statement from the bank before the expiry date. And I think to be fair to the citizens, we are all online now. I would really like if, in addition to the old-fashioned way of communicating, we can simply add or email, since we're asking for it, you see. If we're asking for it, I see no reason why we cannot, in addition to sending it via email and they get it immediately, it comes in the post whenever it comes. But the individual can simply go into his inbox and he knows a notice has been sent from the Commissioner of Valuation. I can read it and I will wait for the written documentation. And I think it would be fairer to the citizens, given the fact that our postal service is highly inefficient. This was for British Post. It's not for current TT Post.
Thank you very much, Madam Chair. Now, I'm seeing an inconsistency here with regards to the method of post, because when you look at section 13, which is the clause that we're addressing right now, clause 8, the registered post is actually deleted. When you go back to section 6, subsection 3, a notice regarding you failing to file your annual return form will be sent by registered post. So why it is you're removing registered post here for the notice of the valuation? Because I think this is extremely important, because this actually forms the basis in which your property tax is going to be assessed. It will affect the time regarding the appeal that you have with the tribunal, or even other appeals that you may want to exhaust.
You have 3 comments.
I will try to remember them all, Chair. Thank you.
Yes.
With respect to registered post, I have experienced instances where registered post actually comes along after ordinary mail, and it's not something that is irregular. So I don't know if that provides the citizen with any more protection other than evidence of when it is received. So that no ordinary post, for some strange reason, tends to be quicker. As I said, Senator Mahabir, the intention is to communicate with the citizen by email as well for greater efficiency, but I would shy away from putting that in legislation at this point in time until we get our electronic system of communication more secure. I don't know if you have sought to do anything through the iGov-TT route. We have had failures in that system, and we are working on it, but I'm not sure when we will get there. So I'd be happy to give an undertaking if that's the intention, but I wouldn't want to legislate. Yeah?
Ma'am, if we are dealing with valuation of properties and communication is being sent by the Commissioner of Valuations under Section 13 of the Parent Act, Madam Chair, and we are given a deadline when the person ought to receive the communication. If it does not arrive, Madam Chair, through you to the Minister, on that particular period that we have identified, what happens? That is going to put everything in a tailspin. Madam Chair, I'm just saying, in the event.
I think the Minister heard you.
I got the point.
Yes.
So I'd say two things. One is that, yes, the person has 15 days to respond from the date of service, but the Commissioner has the right to accept an objection out of time. We have dealt with this provision for decades under the Income Tax Act. The system works. The Board of Inland Revenue, once it is satisfied that the mail has been received late and that you acted within a reasonable time thereafter receiving it, generally gives the extension of time for you to file your objection, and you have a right to object if the board takes an unreasonable position. So I think that provides adequate cover for somebody who may receive the information late, not to mention that this information is a matter of public record. So the owner always has access to the valuation roll to determine whether there's a change or what his current position is. So having regard to all of those things, we didn't think it was necessary to require that it be sent by registered mail.
So, Honourable Senators, the question is that Clause 8 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. The noes have it. Therefore, the amendment as proposed by Senator Mark is not accepted. Honourable Senators, the question therefore is that Clause 8 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 8 now stands part of the bill.
Clause 9.
Honourable Senators, the question is that Clause 9 stand a part of the bill. Senator Shriki Soon has proposed an amendment to Clause 9. Senator Shriki Soon.
Thank you, Madam Chair. Through you to the Honourable Minister. Well, my suggestions for Clause 9 was really premised on my Clause 4 of the bill, Section 5 of the Act, given that if annual rental value was going to be defined as DWE, then there was no need for the rest. But given that we're here, could you just share with me the justification for then removing site value and leaving the rest, if my understanding is correct, in the removal of D, paragraph D, it's the site value of the land.
The section indicates the information that is required to be included in the rules. So whereas the Commissioner from time to time may need to secure or assess the site value, it is not something that we thought needed to be included in the rules.
Okay.
Because
so
the site value is not likely to be an assessment, a valuation approach that will impact the annual rate of value. The capital value is likely to,
Right.
but not the site value. So we didn't think it was necessary to include the site value in the rule, because that would require the commissioner to assess the site value in respect of every property in Trinidad and Tobago, and because it's not necessary for the purpose of Land and Building Taxes Act, we didn't think that was necessary.
Okay, Madam, thank you, Madam. Thank you, Minister, Madam Chair.
Property
Through you
tax,
again.
I'm sorry.
Yeah, no, so I'm just saying that now that you've said that with site value, but site value and improved value would be kind of linked. And we still have, site and improved are linked to some extent. So if we're having site improved values almost similar, so the justification for having it there is, if I follow your argument, if you're removing site, we should also be removing improved and leaving annual and capital.
Because property could be assessed today and there's an improvement tomorrow, sure, and the improvement it should affect the value ascribed, we left improved there.
Okay. And there's one more amendment. Right. Thank you, Madam Chair, again. And just in paragraph key, and this is just in keeping with my presentation during the debate, where it requires where the land is rented, the amount of rent paid on the land and the number of tenants. My understanding is that this valuation rule may be updated probably every 5 years, thereabout, and I'm asking the question as to whether or not the exact amount of rent on the land and the number of tenants is actually relevant to this part in terms of it being so specific, in terms of the amount of rent and the number of tenants, and whether you'd give consideration to the average annual rental earned from the property.
The commissioner valuations in arriving at the annual rentable value will take various things into consideration. One of the things he will definitely want to take into consideration is the actual rent received. Which is why he's also asking for vacancies, the length of period occupied, because all of that will influence it. If we get an average rent from a person, that one, it's subjective, and two, it doesn't give the commissioner all the information he needs to arrive at a proper annual rentable value.
Okay, Madam Chair, just final comment on it. And I understand the direction or the premise upon which you're basing it. But in terms of the content of the valuation rule, not the information being given to the commissioner, should he really be reporting on the valuation rule that element of a specific figure, although he would have had the information collected from the forms?
Yeah, I see your question. The issue is not, in my view, so much whether he should put the information on the roll and more whether that portion of the roll should be made public. Yes, and I am happy to indicate that the information that will be publicly available would not be all the detailed information.
Okay.
Yes, so we will put sufficient information for people to understand where the property is and what the annual rentable value is and that kind of thing, but not personal information that's of a financial nature.
Okay.
Yeah?
Thank you, Madam Chair. So having issues been addressed, I respectfully withdraw. Thank you.
So, Honourable Senators, the question is that Clause 9 now stand a part of the bill. Those in favour say aye. Aye. Those against say no. Clause 9 now stands part of the bill.
Clause 10.
Honourable Senators, the question is that Clause 10 stand a part of the bill. Senator Mark, you have proposed
Yes, Madam
an
Chair,
amendment.
again, consistent with the approach that I have advanced with the Tax Appeal Board and the role of the President in that area. The Minister is replacing the President, and we object to that. So on that basis, we are not in support of that amendment.
Minister? the
Clause
response to
10, Section
Senator Marks.
17, right?
Yes.
Section 17(2) deals with notice of valuation. And this is what the minister has the power to set the date in, to fix that information. And therefore, again, it is consistent with the earlier sections that deal with publication of the roll, the date of effect of the roll, and therefore notification of the information on the roll.
Okay. So, honourable senators, I will propose, yes, Senator Ramdeen.
The amendment that is proposed in relation to 10 is to change minister to president? No? Not in that one. One.
Yes, that's
What
correct.
to change president to minister?
Yeah.
The president here is the president of the republic.
That is correct. In every case in the Act where you see president, we mean president of the Republic, Senator Mark.
So,
But
honourable
the only-
senators, I'm sorry, Senator Ramdeen, you asked one question. You have
Sorry.
something else?
No, the purpose, I'm just trying to find out, Madam Chair, through you, the purpose of that change is to just make it consistent and nothing else? Because legally it doesn't make any difference?
What we are doing is that we are doing valuations. The minister will issue an order indicating when the valuation is effective. Notices will be sent out, and the minister again will determine when that happens. So it does not, in our view, it doesn't make sense shifting from one functionary to the other in respect of the same connected activity.
I'm guided.
So, honourable senators, I shall now put the amendment as proposed by Senator Mark to clause 10 to the vote. So the question is that clause 10 be amended as circulated by Senator Mark. Those in favour say aye.
Aye.
Those against say no. The amendment to clause 10 as circulated by Senator Mark is therefore not accepted. Honourable Senators, the question is that clause 10 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 10 now stands part of the bill.
Clause 11.
The question is that clause 11 stand part of the bill. Honourable Senators, the question is that clause 11 now stand part of the bill. Those in favour say aye. Aye. Those against say no. Clause 11 now stands part of the bill.
Clause 12.
The question is that clause 12 stand part of the bill. Senator Mark, you have circulated an amendment.
Yes, Madam Chair. I am being very generous by proposing 90 days in my amendment. I don't think we should be legislating public service inefficiency in our country. And what the government is seeking to propose here is that if there is an objection and a notice has been issued by the commissioner to that effect, you, the owner of the property, has, according to this amendment, upon the expiration of 12 months after the notice of objection has been served on you, if the commissioner fails to determine the objection, then you can take it to another level, which in this instance is the Valuation Tribunal. And, Madam Chair, I have looked at the Jamaican legislation, and they provide 60 days. 60 days. How in heaven are we proposing 12 months a whole year, Madam President. That it just doesn't make sense. So I would like the Honorable Minister to consider this matter. 12 months is too long. And we are legislating inefficiency. So I have to take action against a decision of the Commissioner of Valuation, and you are telling me I can only take that action to the tribunal after the expiration of 12 months.
Senator Ramdeen.
If we can draw an analogy, Madam Chair, when you have an appeal to the Court of Appeal now, the Court of Appeal which deals with the most complex of matters across the board, there's no limitation, no specialist tribunal or anything like that. Anything. The Court of Appeal sets itself a deadline of 3 months to determine any civil appeal. When the High Court gives you 6 months to deliver a judgment. If this is a specialist tribunal that is manned by persons who are supposed to be versed in the specialities that are required to determine these objections, how could you allow that tribunal a period of 12 months? It's totally inordinate to do that. And then why are you giving, the second part of it is, even if the period of time, whatever that period of time the government thinks is appropriate before it elapses, they are saying 12 months. Well, what are you going to appeal to the tribunal when there's no determination? There's no determination to appeal. So you lodge an objection. The objection is not determined. What is it that you're going to appeal? The appeal is for the purposes of determining a finding. There's no finding. So it's either after the period of time the objection is allowed, or that's the end of the matter. There's nothing to appeal to the tribunal. The appellate process cannot be the same as the first instance process.
Okay.
And therefore,
I think your point has been made. Senator Choate.
Thank you, Madam Chairman. I too think that this is an inordinate length of time. In fact, it must be the longest time I've ever seen for an appeal to be lodged. And I do think that all that it will serve is to enhance slowness within a bureaucratic system. So I do think that the 90 days suggested is reasonable. In fact, I had 60 days in mind, but, 90 days is not outside the boundary, as it were. The second thing is, I'm not clear about one aspect of this, and I'm wondering, Minister, through the chair, whether you could assist me with this. It says the Commissioner fails to determine the objection. So, how could that, is it that the tribunal fails to determine the objection? Because as I understand it, you make an objection, there is some sort of hearing or adjudication upon it, and a decision is then made. Is that what is meant by this, or am I reading it all wrong?
You have to read the act. You have to read it. Sorry. Before the minister answers, Senator Roach.
Thank you, Madam Chair. I just want to associate myself with the comments made in terms of the length of time, it being, unduly long, and that if you look at the Judicial Legal Service, the Judicial Review Act, which speaks to decisions being made or ought to be made, the time given to bring a JR is 3 months, 90 days. And I think that should be kept as a very reasonable position in these circumstances. Thanks.
And then you go to the tribunal.
In terms of the process, the Valuation Division conducts a valuation of a property. If somebody is dissatisfied with that, that person objects to the Commissioner of Valuation. That is the issue that is being dealt with under this provision. The commissioner at that point will review what has been done and determine, based on new information or new consideration, whether he will adjust the value upwards or downwards depending on the information before him. That is what we're asking for 12 months for. We have not yet got to the tribunal stage of the process. The reason why we think that 12 months is a reasonable period is because you will acknowledge that every 5 years, the commissioner is required to value upwards of 700,000 properties in Trinidad and Tobago. If there is a wash of objections sent to the commissioner, there's no way he can handle that. It is not that the properties are being valued in stages as they come on. All the properties need to be valued and the word published at a particular time. And therefore, to ask the commissioner to determine objections in respect of hundreds of thousands, potentially, of objections within 3 months, I don't think that's reasonable. What we can do and what we propose to do is try to expedite the objections, but to say that he has to do them within 3 months, I don't think it will be done. And if we put the 3 months in and proceed to the next stage, what it means is that we will be just sending things forward to the Valuation Commission. The commissioner still has to turn up to defend his assessment, and he will have a high volume of objections in front of him and have to deal with a high level of appeals. It seems to me we're just making the system more inefficient because we are forcing matters down the pike that we may not have to. The commissioner may be able to adequately deal with the objection at his stage if he has adequate time.
Well, sorry, may I? Yes.
Yeah.
That still doesn't give me much comfort with respect to the use of the word determine. I mean, I might be nitpicking, but I'm just thinking that there must be some other word that we could use to indicate that the commissioner has to make a decision, and what he is doing is carrying out a decision-making process when he is met with an objection. So I don't know if perhaps the drafters may be able to, find a better word than that. The other thing is, why don't we then, because we don't want to have this 12 months entrenched in the law and forever after, the commissioner would have 12 months to not give his reasons, as it were, to not give his determination, as it were. Why not put a time frame, say, well, for the first 2 years from the assent of the law or the act, that the commissioner will, this section will operate on the basis of 12 months for notice of appeal to be given, but thereafter it will be 3 months. Would that be at all possible? Because I don't imagine that every year you would be met with the same number of objections. It would be in the inception stage.
Yes, Madam Chair. 3 issues I've got are the determination. That is a term of art. It is included already in other bits of legislation, tax legislation, and there is adequate jurisprudence on what determination means and when it should be regarded to have been given. So I wouldn't want to veer away from that, having regard to the fact that this is another bit of tax legislation. In respect of giving the commissioner the extended time only for the initial assessment, the reason why I'm hesitant to do that is because this same process and the same volume of work will arise every 5 years. And therefore, at this point, I prefer to leave him with the 12 years. And if we see 12 months, and if we see that it is becoming less and less voluminous, I would be happy to reconsider at that point. But because we have no idea what the volume is going to be, and we anticipate a high volume, I would prefer to leave it at the 12 months.
Yes. Senator Roach and then Senator
Sorry, just
Mahabir.
one more thing, Madam Chair. What I forgot to add was that in tax appeals, the standard tax objections, the standard term is either 12 months or 24 months for the tax authority to make a determination, because we understand the volume we have to deal with and the various categories of documents that need to be gone through to properly come to a determination.
Senator Roach.
Through you, Madam Chair, upon the determination by the Commissioner, does that attract any interest or anything while it is pending? Will it attract a penalty of interest?
The tax is not held in abeyance pending the determination.
So you
So
pay.
once the tax is settled, no interest and penalty will arise.
You know, Minister, I understand what you were saying in terms of the reasons for the 12 years. But to me, we have to err on efficiency where this is concerned. Just to make whatever the institution is, to me, more efficient. Give it whatever resources is necessary to keep to the timeline. And I think a shorter timeline will be more palatable for me. I am uncomfortable with the 12. I understand your reasons, but I beg to disagree with it on this occasion.
Senator Mahabir.
Thank you very much, Madam Chair, and Madam Chair, through you. You see, Clause 12, it refers to what exists in Section 9. In Section 9, the Commissioner is guided by Section 9B that the annual rental value of any land appearing in the valuation rule is incorrect. So that if a citizen, Madam Chair and Minister, says to the Commissioner of Valuation that the annual rental value appearing on the rental roll is 500,000, and I have evidence that it should be 50,000, it is incorrect. I do not see any great procedure in simply taking the person's document, instead of having him wait for a year or more than a year and some, to determine what the correct value is. And so when we give the Commissioner of Valuations a full year to perform what I consider to be basic and rudimentary functions, I think we really are building into the legislation a level of inefficiency that we could correct at this stage. Take, for example, the second below that land should not have been included in the valuation roll. So if there's an objection that my land was in the valuation roll when it should not have been, I am sure the information based upon the internal processes and procedures would be readily available to any clerk in the Commissioner's office, not the Commissioner herself or himself, but any clerical officer. Please check and see whether it is correct or not. I don't really see why many of these objections, which are rudimentary and straightforward, should engage 12 months and more of the Commissioner's time, because I consider them to be basic, straightforward, rudimentary, and they should be based upon information already in the possession of the Commissioner of Valuation that he will then use to make his determination. Thank you.
Senator Mark, one final time before the Minister. Yes?
Yeah, Madam Chair, I would like to urge the Minister to reconsider this position of 12 months. It is too long. And maybe you might want to suggest a little lower. I went to 90. You might want to go, a little higher. But it is unacceptable for us to agree to 12 months. The second thing, Madam Chair, I want to draw to your attention is this. In this particular clause, you would have seen mention made of notice of objection. But, Madam Chair, when you go to the legislation, there is no form provided in the legislation before us to guide any property owner on the contents that should guide any property owner as it relates to notice of objection. But when I went to Jamaica, Madam Chair, I saw the form. Madam Chair. There's a form. So any owner who is objecting, Madam Chair, they have a form that can be filled out easily. But here it isn't so. We are making amendments to legislation, and there is no form or forms attached. So this whole thing is subjective. We are not ready, Madam Chair, and we are going to be in trouble.
Senator Mark, though, may I just point out, despite your passion about the form, that the amendment that you have proposed, which is what we are discussing, deals merely with the 90 days from the 12 months. No, that's okay.
Forgive me.
That's
But
okay.
I'll come back to that later. I
So,
take the
Minister?
point.
Yes, Madam Chair. Senator Mahabir, I agree with you that objections that are rudimentary can and should be handled within a short time frame, and that is what is contemplated. But a lot of these objections we don't expect to be rudimentary. I have been through a process of reviewing objections in respect of land and property taxes, and it requires securing purchase documents for documentation, looking at the rate of wear and tear that should be applied to that kind of equipment, determining how it operates in the industry, things that are technical and take some time. With respect to rudimentary things, yes, it could be short, but a technical land and building objection or valuation objection could be a fairly lengthy process. And what we want to do is ensure that we handle as much of what we can handle internally before we go before the tribunal and clog that up.
Okay, but are you contemplating then, Honourable Minister, through you, Madam Chair, that the Commissioner of Valuation be given up to a year, or are you saying he can take 5 years or 10 years to make a determination? Could we not put a time limit?
The year is the maximum.
The maximum. He can take up to a year.
That is what the legislation currently
very
provides.
well. So that
Yes.
will take into account the complex features, but we are contemplating
Yes.
that there should be a determination within a couple of weeks if it's basic.
Exactly.
Thank you.
So, Honourable Senators, I will now put the clause 12, the amendment as proposed by Senator Mark, to the committee. So the question is that clause 12 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no.
No. I think you want a division on this one.
Thank you.
Senator Gopi School? No. Senator Batiste Primus?
No.
Senator Rambarat? No. Senator Sinanan?
No.
Senator Hussain? No. Senator West?
No.
Senator LaHunt?
No.
Senator Henry?
No.
Senator Singh?
No.
Senator Cummings?
No.
Senator De Freitas?
No.
Senator Dookie?
No.
Senator Huggins?
No.
Senator Lewis?
No.
Senator Romano?
No.
Senator Mark?
Yes.
Senator Haynes?
Yes.
Senator Amin?
Yes.
Senator Hussain?
Yes.
Senator Obika?
Yes.
Senator Ramdeen?
Yes.
Senator Mahabir?
Yes.
Senator Roach?
Yes.
Senator Small?
No.
Senator Shriki Soon?
Yes.
Senator Ram Kisoon?
Yes.
Senator Chut?
Yes.
Senator Kreese?
Yes.
Senator Raful?
Yes.
Senator Richards?
Yes.
Result of the division is as follows. 14 members voted for the amendment, 16 members voted against, and there were 0 abstentions.
None, right?
None. Yes.
Honourable Senators, the result of the division is as follows. 14 members voted for the amendment, 16 members voted against the amendment, and no one abstained. The amendment is therefore not accepted. Honourable Senators, the question therefore is that Clause 12 now stand a part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 12 now stands part of the bill.
Clause 13.
Honourable Senators, the question is that Clause 13 stand a part of the bill. Yeah. Senator Mark, you have an amendment.
Yes, Madam Chair. Madam Chair, again, we are very adamant that we should retain the Tax Appeal Board with more resources, more personnel, more judges, make it more efficient. The structure is already there, and not a valuation tribunal in the form that is being proposed by the minister. We are also suggesting for the consideration of the minister a provision that would allow a person who is lodging an appeal shall deposit with the commissioner as a security for the due prosecution of the appeal, such sum as may be prescribed for the particular class of case as he appears in person or by an attorney at law before the body. This is not valuation tribunal. This is supposed to be the Tax Appeal Board in support of his appeal, and that person shall be entitled to a return of the said sum, whatever the outcome of the appeal. And Madam Chair, let me just explain that in countries like Jamaica again, and in Trinidad, we had in the original legislation a provision that would have allowed a person who is making an appeal to the Tax Appeal Board to be refunded the sum of money that that person would have expended. The Minister of Finance has deleted that provision, which was in the original legislation, and has said, if you are appealing, or you're going before a tribunal, or you're going to the High Court, you must bear your own costs. Now, that is very burdensome for citizens. In Jamaica, Madam Chair, there is also the same provision in the legislation where the Jamaican citizen is given state support to appeal at the level of the Revenue Court. So both in terms of Jamaica and in the parent legislation governing the Valuation of Land Act, the previous Patrick Manning administration seemed to have had more heart and more care for the citizens. And he proposed at that time that the state was prepared, Madam Chair, to allow the citizens to be refunded. In this instance, that has not been proposed. So, Madam Chair, I want to go back to the 2009 Act by the former Prime Minister, and may his soul rest in peace, and where he proposed that that be included, and I'm getting solid support out of Jamaica in the Valuation of Land Tax Act for this very provision. So I ask the Honourable Minister to give consideration to the hardships that ordinary people are faced with today, and have some kind of concern for a provision that was in the original act. And the Minister of Finance has now moved it out completely. And that is not fair, Madam Chair. So I'm just asking her to, through you, ma'am, to consider.
Senator Ramdeen.
Madam Chair, thank you very much for the opportunity. Minister, I am very wary some of these provisions that have fixed statutory time limits for the filing of an appeal for two reasons. When the limitation period for the filing of the appeal is laid down in statute, there can be no extension of time of the 30 days. In a normal appeal, we have 42 days to file an appeal. I would ask that you consider both aspects of it. One, that we extend the period of time from 30 days to 42 days, but more so that you provide in this said section a power in the appeal tribunal to allow an extension of time to file a notice of appeal. Because there may be, once it's fixed by statute and you're outside the 30 days, that's it. There should be some form or mechanism whereby someone who has not been able, for some legitimate reason, who has not been able to meet the 30-day time period, which is a very short time period, is able to apply to the tribunal for an extension of time to file their appeal.
And just for clarification, we are speaking on clause 13 and on the amendment proposed by Senator Mark. You are actually proposing further amendments to clause 13.
I'm suggesting, in addition to what Senator Mark has proposed, this is the provision that deals with the section 21,
yes,
subsections 1 to 4.
Yes.
So I'm suggesting, first of all...
I understand. I just wanted to clarify that. Any other comments before I ask the Minister to speak? Minister.
Thank you, Madam Chair. We have explained why we are of the view that the introduction of a valuation tribunal is a good idea in this context. One, we expect a lot of objections. Two, we have found in respect of taxes where you go from the objection section to the tax appeal board, which is a court of first instance, that the taxpayer does not generally get a real opportunity to be heard by an independent, semi-informal body, where a lot of issues can be easily dealt with without having to incur the cost of going to an appeal. Because the tax appeal board is a process that could be expensive. Individuals can appear on their own behalf, but companies must appear through an attorney. So we wanted, before you got to that formal stage, to allow an intermediary independent body to be able to objectively look at this and give the person that opportunity to be heard. And we think the tribunal can do that. If you look, when we get to the provisions of the tribunal, you will see that the tribunal, specifically mentioned in the Act, is the tribunal's what we anticipate or hope the tribunal will do, which is give the parties the opportunity to have a discussion and settle the matter amicably between them. That is not available under the Tax Appeal Board Act. Senator Ramdeen, the tribunal will be given the power to determine their own laws, but we do contemplate some similarity with what's in the Tax Appeal Board legislation, and that does have a provision for an extension of time if you want out of time for filing. Because I do accept that there may be lots of reasons why somebody may not be able to appeal within the right time. Something to that effect? We are leaving it up to the tribunal to determine its rights and its procedure.
Well, you see, the difficult, respectfully, Minister, we've had a situation like this before under the Summary Courts Act, where there used to be a time period of 7 days. And once you file your appeal outside the 7 days, because it wasn't a rule that was laid down by the rules, but was laid down by the Act itself, the statute itself, there was no power to extend the time beyond that. And then the legislature amended the legislation to give the Court of Appeal a power for the purposes.
Mama, let's add one thing here, please.
Yes, Senator Ramdeen, having regard to the fact that the provision does exist in the Tax Appeal Board Act itself, I am happy to put in a provision to that effect.
I'm obliged. I'm very much obliged. Thank you.
Senator Roach.
Thank you, Madam President.
Continue, Senator Roach, yes.
Yeah, I'm just coming back with the 30 days aspect of it too. Yeah, I think it could be extended. I mean, this is what I'm talking about in the equity. We want to give the commissioner 12 months, but we don't want to give the landowner a reasonable more time, 30 days. Make it 60 days.
I have accepted the recommendation. Yes, I have accepted it, and we are going to take it into account. But remember, the taxpayer is dealing with one property, more likely than not. The commissioner is dealing with potentially 700,000. So a reason for discrepancy, but we have accepted the recommendation to legislate for the ability to extend.
All right, so if I could just clarify something. The amendment as circulated by Senator Mark deals with two aspects: the aspect of the tax appeal board, of substituting valuation tribunal for tax appeal board, correct? And then the aspect of the deposit. Yes, but you are, Minister, saying that you are going to accept another form of an amendment, yeah, that you will then submit to the committee. Yeah. So shall we therefore take a vote on the amendment as proposed by Senator Mark and further amended? Because I took down what you said. Senator Ramdeen?
Just to assist the Minister. Minister, perhaps you can ask the drafters to look at the form of the provision in addition to the Tax Appeal Board, the one in Section 130A of the Summary Courts Act. That's where the legislature had given the power as well to extend the time. 130A.
Well, what I was going to do, Senator Mark, was to put your amendment, and then subject to what is determined, then we will stand down the clause. Okay?
Clarification purposes, based on Senator Marx's amendments, I think, I'm not sure if both were addressed by the Minister, no, in the aspect of the reimbursement for expenditure in terms of litigating. What is the position on
that? We are not minded to accept that amendment. The normal rules will allow a taxpayer who is successful and has not brought a frivolous matter before the body to recover his cost and to recover cost, and therefore we think that that is adequate. If we are of the view that if we sponsor the appeals of persons to objections, we will have an abuse of that provision, which is why we removed it and decided that if you bring a matter and there's merit in the matter, then you can seek recovery of cost. And remember that the tribunal is intended to be a more informal setting, and therefore we don't anticipate the cost to be prohibitive, because an individual can represent his or herself and argue his case before the tribunal.
The tribunal has that power to award costs, as in the case of the industrial court?
The rules of the tribunal will be drafted by the tribunal.
So we're not sure. It's not in the Parent Act.
It's not in the Parent Act, no.
You see, so I'm saying, but in the industrial court, the IRA, you could there's a discretion. Usually, it's anticipated as ordinary court, not all of the stringent rules and so forth, right? But in terms of cost, it can be awarded in meritorious cases where it's merited. So I was hoping that something like that could be visited or probably accommodated in this as well, as opposed to waiting for the procedural aspect of it. So it's discretionary. It remains a discretion in good, meaningful, in good cases.
Do we need to put that in the letter?
It's not regularly used, but it is. There are times when it is necessary.
Just letting them.
Senator Mark, sorry, Senator Roach. As I said, we would have considered that during the drafting of the provision, and we don't think at this point in time that that is something that we should prescribe in the legislation. We would prefer to leave it up to the tribunal to determine what its procedures will be.
Senator Mark?
Madam Chair, again, through you to the Honourable Minister, the Jamaican Parliament did not leave it up to the Revenue Court.
I accept that.
They have that in the legislation.
I accept that.
And Mr. Patrick Manning, no, so
Yes,
please.
okay, let us, yeah.
That under the Parent Act, right, the valuation of land, Section 27, subsection 3, Madam Chair, there's a provision that says that if you are appearing before the Commissioner of Valuation, Madam Chair, I'm saying that if the Minister does not want to go to the level of the tribunal and have it inserted here, what about at the level of the Commissioner of Valuation? Because remember, the Commissioner of Valuation is going to make determinations. And if I am unhappy with those determinations, I can go to the Commissioner of Valuation and make my objection. And then he will have his hearing. And I can, now, in this instance, under 27(3) of the Parent Act, here it is, it says, any person attending in accordance with what I've just said before the Commissioner or an officer authorized by him is entitled to have his reasonable expenses paid from public funds by such person and in such manner as may be prescribed. So I'm saying if you don't want to go to the level of the tribunal, because this thing is not compulsory,
So, yes.
understand that it's not compulsory. So to give the person an incentive, Madam Chair, I am suggesting that you adopt or consider adopting the same provision that we had in the parent legislation, Madam Chair. I would like her to consider.
I think, Minister, you have anything different to say? So I think at this stage, there has been enough discussion on this. So I am going to put forward the amendment as proposed by Senator Mark. So, Honourable Senators, the question is that Clause 13 be amended as circulated by Senator Mark and further amended at the second to last line of sub 5 by deleting the words valuation tribunal and substituting the words tax appeal board. Yeah. Those in favor, say aye.
Aye.
Those against, say no.
No. May I have a division on this one?
Senator Gopi School? No. Senator Batiste Primus?
No.
Senator Rambarat?
No.
Senator Sinanan?
No.
Senator Hussain?
No.
Senator West?
No.
Senator LaHunt?
No.
Dr. Henry?
No.
Senator Singh?
No.
Senator Cummings?
No.
Senator De Freitas?
No.
Senator Tukey?
No.
Senator Huggins?
No.
Senator Lewis?
No.
Senator Romano?
No.
Senator Mark?
Yes.
Senator Haynes?
Yes.
Senator Amin?
Yes.
Senator Hussain?
Yes.
Senator Ubika?
Yes.
Senator Ramdeen?
Yes.
Senator Ramdeen? Yes. Senator Mahabir?
Abstain.
Senator Roach?
Abstain.
Senator Small?
No.
Senator Shriki-Soon?
No.
Senator Ramki-Soon?
No.
Senator Choate,
No.
Senator Crease, Senator Rahul,
No.
Senator Richards,
No.
So the results of the division is as follows. 6 members voted for, 22 members voted against, and there were 2 abstentions.
Honorable Senators, the result of the division is as follows. 6 members voted for the amendment, 22 members voted against the amendment, and 2 members abstained. The amendment, therefore, is not accepted. Having said that, Minister, I believe based on your discussions with Senator Ramdeen that you propose to amend Clause 13.
Yes,
Do you
Madam.
have the form of the amendment now?
I believe I do. We are proposing to insert a new subsection 3 to section 21 to read as follows.
No, just 1 second. By inserting a new subsection 3.
Yes.
So that you'll have to have a 1 and 2 of the amendment, or an A and B of the amendment.
Because there's one.
So because you're amending firstly by deleting the words tax appeal board,
Or is it one continuous?
wherever they occur, and substituting the words valuation tribunal, and then you're also
Trying something else?
So, Chair, the First Amendment is as circulated. Yes. And the second proposed amendment is, which is B of Clause 13, by inserting after subsection 2 the following subsection. Upon an application by an owner
Or local.
or local authority for an extension of time to give notice of appeal under subsection 1. Should there be a comma there? Yeah, comma. The Valuation Tribunal may extend the time prescribed to give notice of appeal okay, on any terms and conditions as it thinks fit.
inspectors. The question is that clause 13 be amended as follows, and I'm going to read the entire clause 13. Section 21 of the Act is amended by A, deleting the words Tax Appeal Board wherever they occur and substituting the words Valuation Tribunal, and B, by inserting after subsection 2 the following subsection, semicolon.
3.
No.
Yeah, you have to call
3. Upon an application by an owner or local authority for an extension of time to give notice of appeal under subsection 1, comma, the Valuation Tribunal may extend the time prescribed to give notice of appeal on any terms and conditions as it thinks fit. Yeah? Those in favor say aye. Aye. Those against say no. The ayes have it. The question, so clause 13 is amended, and the question is that clause 13 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 13 as amended now stands part of the bill.
Clause 14.
The question is that clause 14 stand part of the bill. Senator Mark, you
Yes.
propose an amendment.
Yes, Ma'am, we'd like to suggest that, first of all, this valuation tribunal in its current form is not going to serve the public interests, and we will talk about that as we get into that section in a more detailed way. And in those circumstances, we are proposing that the Tax Appeal Board be retained and be properly resourced in order to carry out the function. There will be impartiality, there will be independence, it is a superior court of record, and in those circumstances, we do not see this tribunal ever coming close to the power and independence of this tribunal, well, the Tax Appeal Board. The tribunal, rather, could never come as close as we would like it to come to the independence of this particular body called the Tax Appeal Board. In those circumstances, we are proposing that we delete that entire clause 14, because we are proposing that we retain the Tax Appeal Board and not remove it as the government is proposing, Madam Chair.
Senator Ramdeen.
I was just raising a concern, Madam Chair, to the Minister through you. At the beginning of the subsection begins with if the Commissioner or any person affected by the decision is the person who...
Sorry, Senator Ramdeen, I'm missing some of what you're saying.
Sorry,
Can you speak into the mic, please?
Sorry.
Thank you.
Sorry, I apologize. The beginning of subsection 22(1) begins with the parties who are vested with the right of appeal as being the Commissioner or any person affected by the decision. And then, with respect to the right of appeal being effected in the second line, it says, if you are dissatisfied with the decision of the Valuation Tribunal, the Commissioner or such other person, is there some reason why you moved away from any person affected to, seems to me, to widen the net to such other person? Because it would seem as though the locus to prosecute an appeal ought to either be the same or limited to the persons who have the right of appeal.
But Senator Ramdeen, I have proposed the amendment as circulated by Senator Mark. That's what we're dealing with right now.
Sorry.
And when that is
I apologize.
Yeah, okay. Anybody else? Minister.
Yes, Chair. For the reasons outlined previously, more than once I think, but I'm happy to repeat if anybody wants me to, we have the view that the creation and operation of a valuation tribunal will significantly aid the process of resolving any matters that come up in respect of challenges to the valuation. So we are not at this time prepared to accept Senator Mark's recommendation that we revert to the tax appeal board.
So, Honourable Senators, the question is, that clause 14 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. The noes have it. Clause 14, the amendment as proposed by Senator Mark, is not accepted. Senator Ramdeen, I think
I've explained it now.
Yes, Minister.
Yes, Madam Chair. We believe that the reference in line 3 to such other person refers you back to the persons mentioned earlier in the section. So we don't think that there's a need to repeat the same words.
Senator Hussain.
Thank you, Madam Chair. My issues with respect to subsection 2 of the section itself, of the Parent Act, with regards to the appeal being on only questions of law. I think that we can delete on questions of law only, because it's very restrictive. I know you said earlier that that is how it's drafted, but I know you can in fact appeal both on grounds of facts and grounds of law. So I think that just for clarity, we can just remove on questions of law only. I don't see it being a very detrimental amendment.
And as I would have indicated earlier, Senator Hussain, the right to appeal against questions of law do encompass appeal in respect of questions of fact where the tribunal has made a fundamental error. So we think that the provision as drafted is adequate.
Minister, in that regard, would you consider deleting the word only?
Make a difference, I don't think.
Because
person,
if they could advise, because the word only suggests to me that you are restricting it.
No. Yes, and just to point out, this is consistent with identical to the language that previously existed.
So, Honourable Senators, the question is that Clause 14 now stand part of the bill. Those in favour say aye. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 14 now stands part of the bill.
Clause 15.
The question is that Clause 15 stand part of the bill. Now, Honourable Senators, we have amendments proposed by Senator Mark, Senator Mahabir, Senator Ramkisoon, Senator Srikisoon, and by the Minister. So we have 5 sets of proposed amendments to Clause 15.
Madam Chair, might I suggest that we consider starting with the amendments that we have proposed that may address a lot of the issues raised by the other senators?
Yes. So, Minister?
Madam Chair, having heard the comments from both the opposition bench and the independent bench in respect of the powers granted in our original draft to the minister, we are proposing that where the minister appears in the sections, that is section 25A3, section 25B1 and 2, section 25C, section 25D, subsection C, section 25G, no, sorry, those areas that we replace the minister with the president, and the effect of that is that the president is the person who will have the authority to appoint the tribunal rather than the minister.
Senator Ramdeen.
Lady, Section 80 of the Constitution provides the way in which this operates, in that it says in the exercise of his functions under this Constitution or any other law, the President shall act in accordance with the advice of the Cabinet or a minister acting under the general authority of the Cabinet, except in cases where other provision is made by the Constitution or such other law, and without prejudice to the generality of this section, in cases where by this Constitution or such other law he is required to act in his discretion after consultation with any person or authority other than the Cabinet, and C, in accordance with the advice of any person or authority other than the Cabinet. So that the effect of the amendment doesn't give in reality the power that the minister proposes to give to the president.
Minister.
Yes, Madam Chair. We are of the view that replacing the functionary should give the citizenry enough comfort that there is some distance between the minister and the president, and we think that the clause as amended should remain and not be subject to consultation with the Prime Minister and or the Leader of the Opposition as is being proposed.
I don't think that is what Senator Ramdeen is actually.
Perhaps I'll make it clear, Madam President.
Yes.
What the effect of Section 80 is, wherever you have president, it means the cabinet or the minister exercising the general authority of the cabinet. So if you replace the word minister with the word president, it simply means that you are either going to get the decision, the president has to act mandatorily on the advice of the minister or the cabinet, so that it doesn't give the effect of placing any distance between the ministerial the exercise of power or the cabinet exercising the power. And therefore, at the end of the day, it amounts to the same thing.
Minister.
Chair, I believe that is the issue that I responded to just now when I indicated that the government is of the view that we are happy to replace minister with president, but we would not want to take it beyond that.
Senator Choate, yes.
I support Senator Ramdeen in his concern about the wording of this particular clause. And I was wondering if he could be asked to perhaps suggest a cure for what appears to be a mischief.
Just to answer Senator Choate, the answer is in Section 80B, Section 80A. You just add the words in his discretion so that it is clear that what is triggered is Section 81A, so that the president will be making the determination.
Minister.
Madam Chair, I did seek guidance on this, and the government's position is that it should remain as we presented it. We are of the view that the president would be at liberty to question any instructions that she gets from cabinet, but it should remain as the amendment that we are proposing is as laid out here.
Madam Chairman, may I?
Yes.
I am becoming a little more concerned because what it seems is that we are being asked to use the word president, but mask in a sense the fact that it is upon the advice of a politician, which is what we were trying to step away from in the first place. We were saying that to ensure the independence of this body, that we should take every step that is reasonable to insulate that person from political interference. And
I think we had considerable input in the debates about the conflicts of interest and the potential conflicts of interest and so on. So I do not see that it is unreasonable for us to ask that the words "in his discretion" be inserted to make it clear that this person is acting independently.
Madam President, sorry, Madam Chair. The ministers kindly explained to us that the view of the government is that if the word president is inserted for the word minister, that means that the president has the discretion to not agree with the minister or cabinet. Well,
can you restate what you just said, Minister?
I said that the president would have the opportunity to have a discussion with cabinet in respect of its structures, not that it would be that she would be able to, I'm not sure what words you used, so I don't want to repeat, but that's what I said. I didn't say that.
Madam Chair, for the record, I want to just put on the record that that is not the law. The law, as represented by the Constitution, is that the president must act. He has no discretion to act under Section 80, where the word president is used.
Any other comments? Senator Richards.
Thank you, Madam Chair. Just a question to Minister through you. What is the, if you could, what is the government's concern about adding Senator Ramdeen's suggestion, if it is that the intention is that Her Excellency, whoever the president may be, would have the remit in that particular situation, that particular choice and discretion?
In other bits of legislation where similar powers have been granted, the language is as we have outlined it, and we are concerned about varying from that in this bit of legislation. That is our concern about going another route.
And there is no, through you, Madam Chair, once again, and there's no concern that, because on several occasions the Honourable AG has indicated that president by itself is interpreted as cabinet. And that's where my confusion comes in, as different from what you are stating now.
Well, no, it is not different from what I'm saying now. What I'm saying is that the concern that we heard during the debate on Tuesday was that the minister could act arbitrarily to engage people and to terminate people for all sorts of spurious reasons. And the request that was made of us was to reconsider replacing the minister with the president to avoid that potential arbitrary action. We have acceded to that, and we don't think it's necessary to go further.
One more comment, if you will, Madam Chair. And based on what you said a short while ago, there will be some sort of interaction between Her Excellency and the minister if there is some concern?
It's not the minister, it's the cabinet.
The cabinet, sorry,
the
yes.
Cabinet.
And if there is a disagreement, who has the final say?
Yes, we do agree that the president is required to act on the advice of the cabinet.
So then, at that point, the president really has no say, no final remit. So it reverses to, in my understanding, and limited understanding, to what the cabinet has instructed or advised. So then why involve the president, Her Excellency, at that stage anyway?
Yes, what we have done, as I indicated, is we have moved from a position where the power rests in the minister, who you're saying is influenced by political issues and may act arbitrarily on his own, to the position where it is the president as advised by the cabinet. And we think that provides adequate cover in a situation where we are talking about a tribunal that is below the level of first instance, where you still have 3 levels of appeal.
Thank you, Madam Chair. I've listened to the minister, and I understand the argument. I would like to share with you, Madam Minister, that when I sat on the Joint Select Committee looking at the procurement amendment, the same argument came up when we were dealing with the review board. And the proposal from the government initially was the minister. And the argument went along almost the same line. And the government recognized, one, it was a new institution. And you needed to repose a level of confidence in a new institution. And that on that basis, amongst others, the government took the argument in the discussions at that stage on the review board that it should be appointed by the president. I think that is my concern. It's a new entity. It's not something that it's brand new. And I think what you want to try to do, with greatest respect, Madam Minister, is to imbue a new entity with a level of confidence from the people, from the citizens, that it's completely clean of the political system. So I understand your argument. Your argument is that you've said the minister alone, we remove that. It's essentially the collective view of the cabinet, which insulates, should insulate. And I am not sure if that's enough.
Senator Mahabir.
Yes. Thank you very much, Madam Chair, to the minister. I see the amendment that is proposed by the Honourable Minister, but it makes absolutely no difference to what existed in the initial bill. So it's just a change of word with absolutely no meaning. And you see, I would just like to find out whether the government has made a firm decision that they will change the word only, because my position why I argued in the debate is that I would like Her Excellency the President to make these appointments in consultation with the Leader of the Opposition and the Prime Minister. So I need to get a clear position from the Honourable Minister as to whether it is government's policy that they will not go that route. And if that's the case, keep Minister. Why change, and why put in President simply because it sounds better?
Senator Ramdeen.
Madam Chair, just to assist everyone, if you go to Section 40 of the Constitution, which is the section that allows senators to be appointed, the independent senators are appointed by Her Excellency now, and the section that allows the power to do that says 9 shall be appointed by the President in his discretion. And that is why the President is able to appoint 9 independent senators and choose who the President wants. So you can't get it any clearer than that in demonstrating that the fact that you have to have the words in his discretion in order to effect the political installation that everyone is clamoring for.
Madam Chair, can I also stand this one down? Please.
Honourable Senators, clause 15 is deferred and stood down.
Madam Chair, are we deferring all the amendments, or
Yes,
we're going through?
No, we're deferring clause 15 in its entirety.
Okay. Okay.
And you haven't heard me as yet, huh?
Correct. I've only heard the Minister on her proposed amendments. I will hear everyone else when we review it.
Clause 16.
Senator Mark, there is an amendment on your behalf.
Yes, ma'am. Madam Minister, again, to ensure some level of checks and balances in the minister, doing things without referring to the Parliament, I have asked that this matter be subject to an affirmative resolution of the Parliament, but with your leave, through the chair, I'm prepared to compromise and ask you to consider a negative. So again, whatever he's doing, he would table in the Parliament so that the country can see, and if we find it is objectionable under the standing orders, Madam Chair, we can so file a motion rather than forcing a debate on the matter. So I'm prepared, as we said earlier on, you will go with a negative as opposed to an affirmative. So I would like to consider that as well.
Madam Chair, Section 26 deals with gives the minister the power to prescribe a fee for the production of a certificate of information on the rule. I think that it goes beyond what is reasonable to ask the minister to come to Parliament to debate the imposition of a fee, Madam President. So we are not minded to accept this recommendation.
No, we are not asking you to bring him to the Parliament to debate. That is an affirmative. And that's why I'm saying I'm prepared.
Yes, but he will be obliged to come and debate it if somebody decides to raise it before the Parliament. So if it's a negative resolution, it doesn't avoid the debate. It just means a debate may or may not occur.
Right.
And I am saying for the imposition of a fee, that is unreasonable. The minister should be able to impose a fee for the provision of a service.
No, but
without a parliamentary debate.
Even though we are not elected, we are part of the Parliament and we are lawmakers. And if you are going to impose a fee on the population, it should not be done secretly. And I think you are promoting, I should withdraw that. I think that, for instance, what that would amount to is secrecy.
It's all secrecy. It's just avoiding parliamentary debate. The fee will be made public because members of the public will have to bear the fee.
No.
So it's not a question of secrecy.
Yeah, but listen, Madam Chair,
yes.
May I just bring to the attention of the Honourable Minister that under Section 75(1) of the Constitution, the Cabinet is collectively accountable to the Parliament.
I don't think you have to bring that to the attention of the minister. I think the minister has provided an answer to what you have raised, your amendment, your proposed amendment. Does anyone else wish to raise or make a comment with respect to the proposed amendment of Senator Mark? Therefore, I will now put the amendment to the vote. Honourable Senators, the question is that Clause 16 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. The amendment to Clause 16 as circulated by Senator Mark has not been accepted. Honourable Senators, the question therefore is that Clause 16 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 16 now stands part of the bill.
Clause 17.
The question is that Clause 17 stand part of the bill. The question is that Clause 17 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 17 now stands part of the bill.
Clause 18.
The question is that Clause 18 stand part of the bill. The question is that Clause 18 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 18 now stands part of the bill.
Clause 19.
The question is that Clause 19 stand part of the bill. Senator Mark, you have circulated an amendment.
Yes. Madam Chair, we are talking about Schedule 2 of this particular provision. We find this provision very invasive, intrusive, and we find the provisions to be quite unacceptable in terms of the information that is being requested, particularly when account is taken of the fact that we do not have any guarantee that this personal information can be misused by the personnel who may come upon the said information. In those circumstances, we are proposing that this be deleted completely and be replaced by the original form that is in the legislation that we have circulated. That is the legislation under a bill entitled an Act to amend the Valuation of Land Act, Chapter 5803. And we are proposing, Madam Chair, there is a provision in the previous legislation.
Yes,
not this one that I made an error when I mentioned this.
Okay, Senator Mark, you are proposing that this clause 19 be deleted and that we would therefore revert to Schedule 2 as obtains in the current Valuation of Land Act, correct?
I am in support of that.
That's what you're proposing?
Yes, I'm in support of that.
Minister.
Madam Chair, we have considered Senator Mark's proposed amendment and we are not in agreement. The reason why we have sort of varied the schedule is because the commissioner, is not receiving adequate information on the schedule as previously drafted. We want to make the information return as comprehensive as possible to limit the need for 100% visits to all sites, to limit the kind of visits that we have to effect, and in those circumstances, we think that the information requested is reasonable.
Seek your guidance on this matter. This matter is now under appeal at the Court of Appeal of the Republic of TNT. Leave has been granted on this valuation return form. Do you think it is appropriate, while this matter is pending determination by the Court of Appeal, that this Senate should be interfering with the process in this matter?
Are you invoking a standing order?
Yeah, the sub judice rule.
Minister?
Madam Chair, we were quite careful in reviewing the legislation and bringing amendments to avoid the sections that are the subject of the court matter. Madam Chair, we got guidance and advice from our attorney who is handling the matter, and we do not think that the form itself is under challenge, and therefore it is not a matter that's sub judice.
Yes. Senator Hussain.
Thank you very much, Madam Chair. To the Honourable Minister, now when a person completes this valuation return form and they submit it to the Commissioner's office, can a member of the public who makes an application under the Freedom of Information Act be able to obtain the information as contained in these forms?
It would seem to me that the Data Protection Act would protect the member of the public from the disclosure of that information. The information is being collected for the purpose of the administration of the legislation.
Madam Chair, through you, can I ask the Minister, under what section of the Data Protection Act are we looking at in order to protect this information?
No, well, I think that's...
Just out of clarification.
Well, hold on. The Minister has answered what she's given an answer. Minister, perhaps, I think Senator Hussain would like you to check. I don't know if you have that level of detail, but in the meantime, Senator Mahabir has an issue that he wants to raise.
Yes. Thank you very much, Madam Chair. Madam Chair, the fee was discussed, the fine was discussed at length. It is up to $5,000 at the discretion of the magistrate for failing to file this particular form. But what concerns me is if there is information requested here that the property owner refuses to give, is there a penalty associated with that? Take, for example, Madam Chair, under owner's name, personal information, contact details, telephone number, his cell number, or his email. If he refuses to supply that, he has it, but he refuses to supply it, or his national ID, passport, or driver's permit. He does not supply this bit of information. He supplies everything else, such as the address at which the property is located. Is he committing a breach in any way? Or is it that the citizen is compelled to supply everything that is asked for in this form, including his cell number? And if he does not provide it, what is the penalty for failing to supply information which he has on his personal files and which he does not list on his form? So it's basically my cell number. I did not put it in here. It can be proved that I have a cellular phone and I did not record it here. Am I in breach? Yes. And therefore, what is the penalty for that breach?
Minister.
Thank you, Madam Chair. The information that is requested in the form is not only to allow the commissioner to arrive at a reasonable valuation, but also to allow for easy communication. The information in respect of which willful default will land you in some trouble is where there is a problem with respect to your value, the information provided to value the property. So something like a cell phone or an email omission of that will not.
Very well.
Yes?
Thank you very much.
Senator Mark?
I just wanted to get some clarification, Madam Chair. Through you, are you saying, Madam Minister, that there are sections of the form, right, that would be purely voluntary, meaning that, for instance, if I chose to provide information, accurate information, on certain sections of the form and not to other sections of the form, then there's nothing in the law that can compel me to so do. Am I correct?
What I have said, Senator Mark, is that the information that would, if you fail to provide it, or if you willfully provide incorrect information that may lead to prosecution, is information that impacts your valuation.
Your valuation.
Yes.
Minister, do you have a response to Senator Hussain under the data protection?
Oh, no, well, with respect to the freedom of information, there is provision there to refuse to provide information on the basis of the fact that it is personal information. There is the opportunity for persons to appeal that decision, and we cannot predict how the court will determine. But we have the view that the Freedom of Information Act does provide some protection in respect of personal information.
But in terms of what you said earlier, it doesn't apply.
Senator Mark?
Sorry, ma'am. Sorry.
Yeah. Senator Ramkisoon wanted to raise an issue.
Yeah, thank you, Madam Chair. I just have a question. In relation to items 3 and 6, residential building rents and commercial rents, and we're asking on this form that you have the name of each of the tenants. And my question is, since we're doing evaluation every 5 years, say 3 of those 5 years, the place is empty, the room is empty, the the lease is up and they're not renewed, how does the owner now bring this attention to the commissioner to say that this form needs to be amended? Do they just know that they have to refill it out even though they didn't make the 5 years time?
The information provided on the form with respect to details of the rent received in the particular period and or the tenants will be information based on what provides at the time. What we are going to ask the owners to provide us with updates on is only information that will impact the valuation. So if you construct a new building on the property, or if you do significant revision of the property, or if the property is destroyed, for example, but not things like who are your tenants and what rent have you received in the period. That is a snapshot bit of information.
I could ask the question a little differently then. So you have 10 tenants, right? As a commercial lot, a mall, you have 10 tenants. Out of those 10, you pull out the form that you have 10 tenants. But next year something happens, God forgive, like a leakage or something, and you only have 5 tenants. So you're only receiving rent from 5 out of the 10. So obviously your annual rental value has now been directly impacted. How now does this owner now bring this attention to the commissioner? Because in the form there's no space. So how now do a owner bring this information forward?
The contemplation is that the owner can communicate with the commissioner through written correspondence, indicating any change of circumstances that impact the value, his annual rentable value. And the commissioner will then review the position to determine whether there should be a change.
Madam Chair, just one more. Is it something like they would expect to be doing a notice, or is it something formal?
When in reviewing an amendment put forward by one of the senators, I spoke to the draftspersons, and we did contemplate recommending an amendment different from what had been suggested, but that should cover the recommendation. I don't know if we are at liberty to propose that recommendation.
Madam Chair, when it comes up, we can talk about this. So thank you that it was considered.
So, Honourable Senators, Senator Ramdeen.
To assist everyone, on the issue that the minister raised.
Which issue?
About the data protection.
Yes.
The sections of the Data Protection Act that deal with personal information and the protection of personal information are sections 29 to section 62 by legal notice number 2 of 2012. The only sections of the Data Protection Act that have been proclaimed are sections 7 to 18, 22, 23, 25, and 26 and 28. So none of the sections that relate to the protection of personal data have been proclaimed or are in force.
Okay. Honourable Senators, the question is that clause 19 be amended as circulated by Senator Mark. Those in favour say aye. Aye. Those against say no. No. The amendment has therefore not been accepted. The question is that clause 19 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 19 now stands part of the bill. Honourable Senators, at this stage, we have outstanding clauses 3 and 15. And then we have some new clauses proposed. At this stage, therefore, we will suspend the committee for 15 minutes.
viewing the Parliament Channel 11, also broadcasting on 105.5 FM.